Item. Your speaker is on. Is your speaker on?
Now, man.
Item.
27, man.
You want an upgradation? Okay.
Obliged.
May I please, Your Lordship? I beg to mention item number 33. Kindly adjourn the matter for today, Your Lordship. The
33.
Aegis Council is out of station.
33.
What?
Both sides are represented on the player made trial and transfer to the petition. Yes, after 2 years. Okay.
With your lordship, I beg to mention item number 44, my lord. 44, my lord. My lord, it is in a order matter, my lord. Can it be taken after the completion of the motion matter, my lord? Upgradation.
Upgradation.
My lord.
Okay, we'll consider. We can't assure you, but we'll consider.
My lord. Bail affliction is there. Obliged.
May I please, Your Lordship? I beg to mention item number 6. Okay, my senior is out of station. Kindly adjourn the matter for a day.
6 is a writ petition criminal.
Yes, Lordship.
Let the matter reach, then you renew the prayer.
Lordship.
You will have to pass some order.
Lordship.
My please, your lordship.
You inform the other side.
Lordship, we have taken consent, Lordship.
You have taken consent. Okay. Both sides are represented
I do like.
on the prayer made on behalf of the learned standing counsel for the respondent, the matter stands adjourned today. List on when?
Lordship, next week, any date, Lordship.
Next Monday.
Lordship.
Sorry, Monday would be 27, 8, 2025.
20. Highly obliged.
May I
But
please,
there
your
is a notice been issued in this matter.
Yes, Lordship. Today is the third day, Lordship.
my please, your lordship.
I do.
My lord, I beg to mention item number 24, my lord. My lord, this matter may be taken on next week, my lord.
24
24.
weeks. Same.
Obliged, my.
Item 1 for motion.
Maybe the lordship. My lord, item 1 and 41, perhaps both these matters were heard on earlier occasion. Learned Advocate General was also present.
Let him come. He'll address us.
Look, we have to file an affidavit in this case, madam. Item number 1.
He will address us.
Yes,
Today,
Yes.
the educational, there are many matters fixed. He'll address us
we will address, madam. He's coming, but
Now,
after some time.
regarding this, I have also given two citations of the Honorable Supreme Court that pending deportation of the
We'll take
declared
up after some time. Let the advocate general come.
what? Item 2. 2, 3, 4, 5. It's all of this.
Item 2, 3, 4, 5.
2,
Same.
3, 4, 5, same, man.
7.
7 is not our.
2, 3, 4, 5.
Item 7 for motion.
Your Lordship, kindly pass over the matter for some time, Your Lordship.
Just let me see the file first.
I'm taking instruction.
Right, okay, just one file. Okay, let the council come. Was it?
All right, Your Lordship.
Item 8 for motion.
8 also same, my lord. 8, 9. 8 and 9 also relate to same issue, my
Eight
lord.
and nine are same.
Yes,
Advocate General will come.
my lord, no. 10 is different. 10 is,
Hmm?
10 is different.
Then is different.
Item 10 for motion.
Appears on call for the petitioner. All the respondents have been presented. Next. So the office note dated 17/7/2025 for the cost title has been corrected in terms of order dated 14/7/2025. Which though order has been passed on 14/7/2025. Issue notice of motion returnable. This would keep the issue of maintenance be open and notice was issued returnable on 18/8/2025. As the first title has been corrected only on 17/7/2025. This notice as issued by order dated 14/7/2025 is made returnable on due date after 4 weeks. Returnable also. Extra copies of the petition be served on the Runnet CGC, State and Departmental Council within 2 days. Expected.
Those number.
That the relevant record be requisitioned from the concerned tribunal. And if the following email address of the said tribunal. Prayer for bail shall be considered on receipt of the record of the tribunal. Next list on Swenson.
Item 11 with 12.
Shall be considered receipt of records. Sometimes. Bye. Item 13. It appears on call to the petitioner. It's also for the respondents. By calling this petition in Article 226 of the Constitution of India, or the petitioner has said, petitioner namely so and so has essayed the opinion dated page 69.
Thirteen.
Dated so and so passed by. So and so, take my phone. Passed in so and so, special reference case number so and so,
Then this,
police reference case number so and so.
what time?
Thereby declaring the petitioner to be a foreigner post 25/1971 stream. Notice extra copies within 2 days, call for the record. The prayer for bail shall be considered on receipt of record. Next one, in the meanwhile, if the petitioner namely Rashid Ali son of Muhammad Aziz Ali, alias Aziz Ali, age 69, is apprehended, I shall not be deported out of the country without order of the court. Same thing. Okay.
Item 14,
Same author. Page 54 is the opinion dated. Eighteen 12/2023. Passed by so and so in so and so, SP reference number so and so, SP reference number so and so. Thereby declaring petition to be a foreigner post 25/1971.
item 15,
May please, your lordship. My lord, here, my lord, the input order is at page 87. Is 87. My lord, here in this case, my lord, the petitioner appeared before the tribunal after receiving the notice filed WS evidence in chief of herself and her brother and one, my lord. Is 87, my lord, please. My lord, ultimately because of not cross-examination, not facing the cross-examination, the case has been closed, decided ex parte, my lord. My lord, SPB Bongaigaon. Deep love legislators.
Item 16 for motion. Item 17.
Please, Lord. Lord, by being opinion at page 109, my lord.
Gulaghat.
Gulaghat, SP Gulaghat. Oblige.
Yes, Lordship.
I'm ready, yes.
Item 18.
South Salmon Mankatar. South Salmon Mankatar. Yes, Lordship. Yes, Lordship. But I think Lordship record is at South Salmon, Lordship. Yes, Lordship.
Item 19.
Our drinking order is page 62. So order dated 14/12/2021. Some delay is there. Page 52.
September.
I'm praying for bail. Praying for bail.
Item 20.
May please, your Lordship. Lordship, you can export the opinion, my lord, export the opinion in case 48. You don't never receive the summon. 482. Because summon was not served upon me, Lordship. Did you? Order to prepare. Recent order. Jobs Act 25.
হেৰিটো দিছে, নটিচটো দিছে। এতিয়া লিখা আছে, ৰাজনীতি লিখা আছে। This, my lord, protecting him, let the record be called. Protection may be granted, my lord, let the record be called. My lord, yes. Yes, that I admit, my lord. That part I admit. That's why, my lord, let the record be called for, and he may be protected for the time being. There are some issues also, my lord. That's fine. At this
My lord,
instance.
humble prayer, my lord, notice was never served me, my lord. My lord, if
Yes, there are some developments, my lord said. That's why let the notice be issued at this moment, and intermittent and.
publish notice.
Item 21.
Yeah, please, Your Lordship. My lord, the impugn opinion at page 77, my lord. The yes, ma'am.
Beautiful. Chief Sagar.
SP Shivsagar, my lord. Obliged.
Item 22 for motion.
Let me look.
My lord, impugn opinion at page, my lord, 103, my lord. Operating part, my lord, at page 108.
Opinion dated 29/4/2020.
19/9. Time being item 7 for motion.
Yeah, this is. Party করার কথা আছে কারণ স্টিক পার্টি করা বিশেষজ্ঞ স্যার এটা আছে না স্টিক পার্টি করে বলে বলতে দিবি এসে ভাইবা হ্যাঁ লিখা না কিন্তু হবে দিয়া কোনো হয় এটুকু না হবে এও কেস করে তো পাহাড় ঘর everybody is not recording. Okay.
Yes, yes, sir. He confessed, accused already confessed that he had intended to kill missing woman. So Lord says the last page, he con. Yes, yes. Hence, police already said that hence the case is pending for further investigation. After 1 month, my lord. Nothing, nothing good. Party.
Obliged.
Daily list item 1 for motion.
In this case, in terms of the direction passed on the last occasion, Lordship, we have filed the affidavit, which was filed on 14th of this month, and the other side has also received the affidavit. In the affidavit, we have basically stated that the person concerned, Lordship, he was declared foreigner and there is no pending case to challenge his finding against him. And he was in our detention camp. Then after the Supreme Court passed the order that those who have completed 2 years, he was released. Now on 25th, he was again picked up because he was awaiting deportation from the detention camp or holding camp. So on 25th, we have all the formalities were completed. So he was picked up, handed over to the BSF authorities who are under the central government, Lordship. And BSF has informed us that on 26th, he was deported to Bangladesh. Yes. Thereafter, if Lordship is pleased to come to paragraph 5, page 29. The deponent states that though the declared foreigner Sahamat Hussain, alias Sahamat Ali, failed after his declaration as illegal migrant in the Honorable Guwahati High Court and Supreme Court, but he was released on bail pursuant to the orders of the Supreme Court in WPC so-and-so on completion of 2 years in detention as he could not be deported at that time with the same terms and conditions. Paragraph 6. Here we have stated the actual facts. The deponent state that the government of Assam has now initiated the process of deportation of declared foreigners
in consultation with the government of India, the declared foreigner, namely Sahamat Hussain, picked up on 25th of May 2025, and after verification of documents and other facts, he was handed over to the SHQ BSF, that is the BSF authority, Dhubri, for deportation to Bangladesh. However, the BSF again handed over the DFN to Assam Police on 29/5/2025, stating that though he was deported on 26/5/2025 to Bangladesh, the DFN again entered into Indian territory on 28/5/2025, where he was caught by the BSF and handed over to Assam Police. Since then, he has been kept in holding center at Saraikola, Kokrajhar. So my humble submission before is that, Lordship, now he is under the custody of the state police in a holding camp. Again, we are initiating the process for his phase deportation. So the benefit which they want to take in terms of the Supreme Court order, that those who have completed 2 years of detention and awaiting deportation, they should be released at the time of COVID. So that benefit he has already got. And once our formalities for his deportation was completed, we have handed it over to the BSF. BSF have deported him and he again returned. He re-entered India. So a fresh cause of action has arisen in his case. His chapter was closed on 26th of May when he was deported to Bangladesh. So all the benefits he got from the Supreme Court, that ended when he was handed over to BSF by the state police on 25th of May, because he was outside the deportation, outside the detention camp or holding camp during the period from 2021 onwards. So he obtained the benefit, he got the benefit. And when the formalities were completed, he was sent to Bangladesh. So he was deported. So in my humble submission, the benefit which they want to invoke the Supreme Court's order that 2 years of detention is sufficient for his detention, thereafter he is entitled for bail, that will not be applicable in the instant factual matrix. So that is my humble submission before this honorable court. Other 4 cases are also on identical footings. The other side, Lordship, if they want to file a counter, because the others, when the matter was taken up on the last occasion, they made a submission that they will verify what we are stating. We are stating the same things on the earlier occasion. There was no affidavit. Therefore, this honorable court directed us to file the affidavit. Now, if they want to counter these factual things, if they want to rebut, they are entitled to do that. But he will not be released from our side unless this honorable court directs. And in my humble submission, that liberty may not be given to them, because he is a declared foreigner. He is a deported foreigner. One more term we are adding now. He is a deported foreigner. So he is no more a declared foreigner. He was declared and he was deported now. So declared and deported foreigner. So therefore, again, he re-entered India illegally, without any visa, without any passport, without any documents, without any permission. So that is my humble submission, Lordship. I leave this honorable court to pass an appropriate order dismissing the petition where they are seeking basically bail. This is my humble submission. My colleague will be here, Lordship, for the other cases. Identical facts, all. Highly obliged.
Dear Lordships. My lord, actually, they have filed affidavit. We have also received the copy of the affidavit. But we think that reply affidavit may not be necessary, because there is the order of the Supreme Court. When there is the order of the Honorable Supreme Court, by filing affidavit, that cannot be overpassed. So the Honorable Supreme Court, in case of suo motu writ petition, civil number 1 of 2020, the other day I have given the copy to your Lordships.
Annexing the affidavit, but affidavit also you have annexed.
So in suo motu writ petition civil number 1 of 2020, so here order dated 13/4/20. That in that case manner, in that suo motu writ petition, the Honorable Supreme Court, there was various IS, my lord. In the same case, there are various IS. One IA was 48215. 48215/2020 and IA number 48216/2020. Here the Honorable Supreme Court said, well, these are very important. Insofar, Lordship has seen, my lord, that order. Insofar the release of detainees who have served long periods of detention in the detention centers, awaiting their deportation. This is very important words. Awaiting their deportation is concerned, we are of the view that the detainees who have completed more than 3 years may be released subject to the following conditions. Now, these 3 years have been reduced to 2 years. Kindly see thereafter, next page, last para. Having regard to the present circumstances prevailing in the country, and having regard to the fact that we have already permitted the release of prisoners and people under detention in general, this is very important, in general, and such detainees who have completed 3 years upon their declaration as foreigners, we see no reason why the period should not be reduced from 3 years to 2 years. That is to say, the prisoners or detainees who have been under detention for 2 years shall be entitled to be released on the same terms and conditions as those laid down in the aforesaid order dated 10/5/19, except that they shall not be required to furnish a bond in terms of ₹1 lakh. Instead, they will be required to furnish a bond of ₹5,000. So, my lord, first lordship, it is said clearly, those detainees who are awaiting for deportation, they were said to be released after 3 years. Thereafter, the Honorable Supreme Court modified the order, and instead of 3 years, it has been made 2 years. And instead of ₹1 lakh, it has been made 5,000. Now, this is the law of the land, my lord. Now, my learned friend, Mr. Advocate General, has said that they were deported, and so the fresh cause of action arose. My lord, it is very difficult to believe. Because if this person is deported, how he came? There are raw personnel, CBI, CID, police, military, BSF, so many persons are there. How this person will go to Bangladesh and then will come back in front of this so many forces? So it is difficult to believe. So the order of the Honorable Supreme Court would come into force that as I was more than 2 years in custody, after declaration of as illegal migrant, and I was awaiting for deportation, they tried to deport me but could not. I was in Indian soil. Had I been entered in Bangladesh, definitely the Indian security forces were available in the border area, they could have detected me. But I was there, then the BSF having the alternative, they handed over me to Assam police. Assam police kept me in the holding center at Soraikhola at Kokrata. Now, holding center and detention center, names may be different, but the purpose is same, my lord. In detention centers, people are kept, and holding center also, that is, my lord, a kind of giving some surprise that no, this is not detention center, it is holding center. Actually, the meaning is the same. They have been kept there. Here also they are kept here. So, my lord, by changing the name, the order of the Honorable Supreme Court, the spirit of the order cannot be defeated. So, my submission is this, my lord. This item 1 and 41 is also same, my lord. 41. My 2 items today. This 41 and 1 are on the same footing. Both of them were in detention camps awaiting deportations. And by your lordship's order, both the parties went to Soraikhola at Kokrajhar. They met, and he is lying there in a very pathetic condition. I have been told that there is one toilet, so many inmates are using that. So situation is also not hygienic. And moreover, that is another aspect of the case. Main aspect of the case, as I was in detention camp for more than 2 years, and as there is order of the Supreme Court awaiting deportation. This is very, very important and crucial word. So we are awaiting deportation. So, but it could not take place because there is no international agreement between the two countries. So it could not give any effect. And we have also made certain observations in our writ petition. For a moment, I draw your lordship kind attention that may be seen. That may be seen, my lord, para 7. Para 7, page 8 of my writ petition. With your lordship's kind permission, I am reading that the petitioner insisted that the United Nations General Assembly, through resolution number 40/34, dated 29/11/1985, has declared some basic principles of justice for victims of crime and abuse of power, which was adopted and has to be followed by Government of India also. In addition to this, the Rohingyas, who are admittedly foreigners, when the government wanted to deport them, the Honorable Supreme Court, by order dated 8/8/21, passed in interlocutory application number 38048 of 2021 and writ petition civil number 793 of 2017, reported in 2021 INSC 239296 Mohammad Salimullah versus Union of India and others, made it absolutely clear that no deportation can be done without following due procedure of law. Moreover, the Universal Declaration of Human Rights 1948, which has been otherwise followed under Article 21 of the Indian Constitution, has also not to be to be followed. It is not wrongly written. Also to be followed in the present case. For all these reasons, the detention of Shahamad Ali and his whereabouts about after being taken into custody is an undisclosed. That was at that time. But the first part is applicable in our case because India is the signatory of Geneva Convention. So, in such a manner, my lord, whether they can be kept, and that too when there is the existing order of the Supreme Court. Our humble submission is this: both here the petitioner is the son-in-law of the detainee, Shahamad Ali, and in 41, that is husband of the detainee, Mujibur Rahman, and his wife is Manikjan Bibi, alias Begum. So both these two persons may kindly be released on bail at the hand of two Indian citizens with conditions as have been given by the Honorable Supreme Court, or some other conditions may be also imposed by your lordships. Keeping them behind the holding center would serve no purpose because they are eating the government foods, everything. Now, if they come out, they will do something and will earn their livelihood. And whenever there would be an agreement in terms of Geneva Convention, Universal Human Declaration rights, then they may be deported. That is my humble prayer. Obliged. Same argument in item 41, my lord.
Item 2 for motion.
May I please, Your Lordship? Lord, item 2, my lord, it is also identical matter, my lord. Earlier, the Honorable High Court was pleased to reject the petition, my lord, and thereafter, my lord, on 25/5/2025, my lord, she was arrested. And before that, my lord, after declared foreigner, my lord, My lord, earlier, my lord, the petitioner was arrested, my lord, and she was released, my lord, on 22/11/2022, as per the order passed by the Honorable Supreme Court, my lord. My lord, thereafter, my lord, she approached the Honorable High Court, and the High Court was pleased to dismiss his petition, my lord. And my lord, on 25/5, my lord, 2025, she was again taken into custody, my lord. And already, my lord, she gathered all her documents to, my lord, approach the Honorable Supreme Court, my lord. Again, the order passed by the Honorable High Court. So, my lord, she may be released on bail, my lord, to provide the opportunity to approach the Honorable Supreme Court. Because, my lord, my lord,
In this item, my lord, item number 2, my lord. In this case, my lord, he is not deported. She is not deported, my lord. She is at holding center at Madhya, my lord. He is awaiting for deportation, my lord.
Hmm. 817990. note. Lord, next item. Next one is, my lord, here, son of the detainee is.
Item
petitioner.
3.
Here, my lord, after declaring foreigners, my lord, he was taken into custody, and as per order of the Honorable Supreme Court, he released on bail, my lord. And thereafter, my lord, he did not approach the Honorable High Court. In the meantime, my lord, on 25/5/2025, he was again taken into custody. To proceed. In this case, my lord, the respondent number 2, my lord, has filed their affidavit. My lord, that there is a common judgment, my lord. The petitioner, along with many others, were declared as foreigners by an ex parte order. That is at page, my lord, 48. And after, my lord, declaring foreigners, he was taken into custody. On 25/5. Okay. Any answer?
Release order.
Lord, in common order at page 58.
Release order.
Release order, my lord.
Said he was released on bail. Here is the order.
Earlier, he was not taken. And on 25/5/2020. Huh? Okay, okay. Itu kan. Yes, 48, my lord. His name is at serial number 1, my lord. Okay. And the opinion dated at page 52, 28/02/2022. No, my lord. And the even no summon was received, my lord, and the petitioner has no knowledge.
In this case, my lord, the petitioner never received any notice from the tribunal, for which he could not appear before the tribunal to contest his case, my lord. The petitioner came to learn on 25/5/2025, when he was arrested, my lord, that a ex parte order has already been passed against him. This is a common order. The petitioner, along with many more, my lord, they were declared as foreign, the same nation. Nobody received, my lord, any summon from the tribunal. Hmm? এখনো common order. So, my lord, the
He was deported and he came back again. Here, the detainee was deported, my lord. It is similar to item number 1, my lord. He was deported and came back again. It is in fact, my lord, the better, in fact, it is, my lord, this is better for us in compared to item number 1, because there is, he was not arrested, and in pursuance to Honorable High Court or Supreme Court order, he was not released. There was no release, nor he was arrested. So here he was detained first time, and he was taken into custody. He was sent back to BSF. BSF handed over the deported. Then he again came back. On the next day, he was caught and he is handed over to Assam Police now. See, the Supreme Court's order will not come into play in this case, madam.
My lord.
Yes. 22. Yes.
My lord, he was detained, my lord, from his own house. Thereafter,
Sorry.
okay, sir.
Item 3.
Yes. No, precisely that is what we were telling you on the last occasion. You see, you can't be allowed to file successive writ petitions. You have filed a habeas corpus petition that is also under 226. And your cause of action is same, ex parte opinion. You have to satisfy us that the successive writ petitions can be filed, even if it is habeas corpus. You could have maintained the habeas corpus petition and challenged that opinion also, that you did not do. That's why we asked you to take a call and what is to be done. No, we won't say anything. It is for you to take a call. But so far as leave is concerned with this pending, we can't give you leave. It will be successive writ petition. Hmm? No, that's a statement. What is your prayer? But then you'll have to withdraw this. Without prejudice to your prayer for habeas corpus, you have to make a consolidated challenge. Successive writ petitions, we don't know. We have to satisfy us whether it can be filed, even if it is habeas corpus. Normally, it is hit by principles of Order 2, Rule 2.
But are we in item number 3, madam? This is item number 3, madam.
Yes, we have 3. 2 is also same.
Yes. Item number 3, my lord, this is, in fact, here the person has been deported, madam. And he was deported, he came back again. So the another cause of action error.
No, that's okay, but once it is a challenge to the opinion,
Yes.
that challenge could have been maintained. Yes. Okay. What is the petition number?
29 of 2025.
Order dated? Order dated? You're not aware.
29, 29, 25, 28.
Damn it, just please check up. WP Criminal 25 of 2025. 29 of 2025. Last 24 June. Please give a printout. Mr. Ahmed, you have given us so much of trouble to find out this order and then take a printout, and then is the same thing which we told you. You can't maintain two petitions. This here also the petition was closed, giving you liberty to make the challenge. You don't say that, but you say that you have this order. We'll have to hear it from you. If you want the matter to be closed, you'll have to make a prayer. You can't maintain a prayer of the challenge and then ask us to close the petition. That you can't. Unless you make that prayer from your mouth, we won't hear it. Prayers can't be presumed. Okay, we'll pass orders. If you don't say it, we pass orders. Unless you make a prayer, we are not listening to anything. You're not pressing this petition. Either tell us that. You would have closed it long back. Yes, take it down. But Mr. S.A. Ahmed, learned counsel for the petitioner, also heard so and so for the respondents. Next paragraph. The case of the petitioner. So this order is there. Only do the relevant changes. I'm not giving you a dictation. This opinion is at page 48. Date serial number 1. There are many cases. 48 serial number 1. Red pencil. The detained person is your father. Into paragraph 4. The learned counsel for the petitioner has submitted that pursuant to order dated 6/8/2025, comma, passed by this court in this writ, in this writ petition, comma, the petitioner along with a family member had been allowed to meet the detained to meet the declared foreign national, and his signature in the Vagaratama has been obtained. Accordingly, comma, the learned counsel for the petitioner has orally prayed that this habeas corpus be closed with liberty to the petitioner to liberty to the detained foreign national to assail the said ex parte opinion dated 28/2/2022, passed by paragraph 2. Next paragraph. The prayer is allowed, and this habeas corpus petition stands closed. Full stop. However, comma, in order to enable the declared foreign national to challenge the ex parte opinion, the court is inclined to provide that for a period of 30 days from the date of this order, comma, the said Abdul Ali shall not be deported out of the country without order of the court.
One thing, my lord, in this case. If it can
Just
be
a
mentioned,
moment.
madam.
Just a moment. Yes.
No, no, because unlike the another case, my lord, the 29. Here in this case, this my lord, the petitioner, the detainee was my lord handed over to the border police, BSF, and he was sent back to the foreign. As my lord, my lord, the advocate general has argued, he is not only now declared foreigner, he is a deported foreigner. Once he was deported, he again come back. This is another illegality they committed.
No, but that has got nothing to do with the challenge to the opinion.
Yes, ma'am. So that, my lord, that's why that matter, that issue may that matter, note that may be mentioned here in this case, because that may be mentioned in the order matter.
Acha, okay. Acha,
And
after
that
that prayer,
matter,
after the prayer to close this matter, you say at this stage, the learned standing counsel for the FT matters has submitted that as per the stand taken in the affidavit in opposition filed by respondent number 2, comma, the declared foreign national was taken into custody on 25/5/2025, and after verification of the documents, comma, he was handed over to the sector headquarter, comma, BSF, comma, Dhubri for deportation to Bangladesh. Full stop. However, comma, on 28/5/2025, comma, the BSF had handed over the said declared foreign national to the Assam police by stating that though he was deported on 26/5/2025 to Bangladesh, comma, he had again entered into the Indian territory on 28/5/2025, and he was again apprehended by the BSF and handed over to the Assam police on 29/5/2025. It be 29, not 28. 29/5/2025. Here, there are two dates you are giving, page 81. In the middle, you are writing handed over to the Assam police on 28/5. Then third last line, you say 29/5, which is correct.
and third on, my lord, page
Page 81,
81.
in the
and
middle, you say how the BSF handed over the DSF to Assam police on 28/5. Last three lines, you again write 29/5.
29/5. Assam police on, my lord, JFN entered again in India 28/5. He entered.
No. Read it carefully.
Yes, madam. It should be 29. Madam. 29.
You better ask your officer because
No, it is on 29.
you better ask your officer. Call this officer and then confirm it.
Return to your 22 return was the 29 of this month. And my lord, they re-entered on 28, caught on 28, handed over to us on 29. That's clear.
Make that correction. Entered into India on 28, apprehended on 28 and returned and handed over to Assam police on 29th. Okay.
So, my lord, that's why, my lord, the merit of this case, that case may be, my lord, this may not affect in that merit on that case, my lord, if they file.
It will, you tell us how will it impact?
No, my lord, because, my lord, they may claim that this honorable court has allowed us to file a writ petition.
Yes, that
So
we are allowed.
maintainability of that writ petition will be, my lord, open for.
No, that you will have
merit
to
of-
challenge in that petition.
Yes,
We can't partly adjudicate that case which has not come
Yeah,
now.
my lord, no, that maintainability of that case may be, my lord, be on their own merit of that case, my lord, not.
We are not
Really-
saying anything. That will come when the writ petition comes.
No, my lord, they may claim that, my lord, as this honorable court has allowed us, so we have the right to.
If he's a good, if the petitioner is supported by a good counsel, you become a better counsel to oppose it. Next. It was a. Yes, item 4. Yes. Please speak loudly. Is your okay, same order as the last one? Okay. It is the same order as the last one. Same counsel. Here, just take a note. The name of the petitioner is Alim Hussain, ALIM, HUSSAIN. The declared foreign name of the declared foreign national is AIOB. Oh, sorry, Mohammed MD. Ayub Ali, alias Ayub AYUB, Ayub Ali, father of the petitioner. He was declared to be a foreign national by the opinion dated 26/2/2021, page 36. Next date is he was taken into custody on 25/5/2025. Next, as per the instructions of the learned CGC, as recorded in the order dated 6/8/2025, the said declared foreign national was handed over to the border security force along with a total number of 109 declared foreign national. Stop. The said Mohammed Ayub Ali alias Ayub Ali was corrected by the border security force on 26/5/2025, and in the intervening night of 26th and 27th May 2025, the said declared foreign national was sent back to Bangladesh from the capital A, small o, capital R, within bracket, area of responsibility, bracket close, 157th Battalion, BSF, full stop. However, it was found that the said declared foreign national has returned back to India on 28/5/2025. Full stop. He was once again apprehended by the BSF and handed over to the 7th Assam Police Battalion, Saraikola, Kokrajhar. in the said statement of the learned CGC is supported by the learned standing counsel for the FT matters, who has referred to the affidavit in opposition filed on behalf of respondent number 3. The same. Please follow with liberty. Same one.
Item 5.
Yes, we have seen that page 30.
Petitioner, my lord, petited the detainee, and my lord obtained the Mukalusnama and the other necessity.
Okay. You want this to be closed?
Yes.
The same order. As per the last dictation, only the names will change. Opinion dated 26/2/2024 at page 30, passed by so and so and so and so. Petitioner, name of the petitioner is Ansuma, ANSUMA, Ansuma Begum. Mother, Jahira, JAHERA, Jahira Begum, has been declared to be a foreign national, right, so and so. Next, same date, it's just taken into custody on 25/5/2025. Collected, BSF collected on 26/5/2025 with 109 declared foreign nationals. Same Bangladesh 157 battalion, same.
You're also going to see return back.
Yes,
She
yes.
returned.
The date of returning back is not there. 28, let's
Or
just
20.
tell us, same 28, same, it will be same, 28, return back 28. Handed over to the Assam battalion on
29.
20,
Handed over on
to the
29.
7th Assam Police Battalion, Saraikula, Kokrajhar on
29.
29th.
29.
Rest will be same. Okay.
Item 8 for motion.
Can it be taken from other day without?
Do some other day. You say both sides are represented. The prayer made by Mr. A.W. Oman, Commander and Counsel for the petitioner. The matter stands adjourned today. Next para. It may be stated that Mr. D. Cycle and the Advocate General for the state has appeared in the matter and has submitted that his submissions made in connection with the proceedings of WP within bracket criminal bracket post 44 of 2025 dash Mohibul Islam, MOHIBUL Islam versus Union of India and others will suffice for this case also. Next para, be that as it may, matter stands adjourned today based on It's on 27/8/2025.
Item 9.
Pardon me? Timing. Adjourn for the day. Here also, we forgot
Yes.
here also AG's submission will cover.
Same.
Okay, same order, only the name of the council will change. On the prayer made by Mr. S. Abdullah. Council to the petitioner, same order passed. List on the same date, 27/8.
Supply item 42.
Supplementary to 9.
Supplementary, it is not supplementary, orders. Mainly.
Mhm. You give it a copy to Mr. Payang.
Take it.
You'll take it up day after tomorrow. You make your
Yes.
response on day after tomorrow.
Yes.
Item 42. Mr. D.K. Agarwal and counsel for the petitioner has submitted his has submitted a written argument on behalf of the petitioners. Full stop. Let a copy thereof be provided to the learned CGC, state and departmental council. Next para, list on day after tomorrow, it's 20/8/2025 for submissions of the respondents. Same, this will cover. Okay, same order. You have filed this, this is a written argument for 42, 43. Okay.
1 to 10 and dictation 1 against
Chamber. Okay. 11, 12, who is there? Yes, Mr. Dutta. No, item 11, 12, they are taken up together. Okay. It's a common opinion? No. Where is the opinion on which you are relying? In which item? Item 11 or 12? Item 11. Page? No, this is your opinion. You say that it's a covered matter. No, no, no. You are saying that this is so some other family members have been declared to be Indian. Where is that opinion?
Item number 12. Basically,
No, no, that is not he's saying. He's saying that he is covered by our family member has been declared to be an Indian. That's what you're saying. Okay, we'll resume at 2 o'clock. Yeah, we'll take it up at 2. Yes. Pardon me? Item 11, yes. Yes. What has happened to writ patient 3560? WBC 3560 of 2019. No, no, you come to page 18, paragraph 26. You have made a specific statement. Okay. And you see, apart from the delay, if you are referring to 4136 of 2029, in that case, order dated 31/3/2023 was passed to explain why two villages are different. That affidavit has not come. No, because this is otherwise very serious. You see what has happened here in this item number 12. You refer to a voter list of village Mahaguri of Moza Juria in the district of Nalbari. This contains the, not Morigaon, it is Mahaguri. Whatever be, I don't read that seriously. It is Mahaguri, correct? Moza Juria. This is in the name of where is that voter list? 1965. That is at page 18. Correct. Now, this contains the name of Is Bali, son of Asardin. Correct. Now, this again a voter list of 2014. Where is that? 26. Yes. Now 26. This is village Narmari. Correct. And here Samaruddin, son of Isab Ali. Correct. Now come to 1997 voter list. Page 24. Then you see the father's name changes. There is no explanation to that. Therefore, you are manufacturing the family on the basis of voters list. No, but you can't be given so much of time. Next time you don't expect me to, because every time it comes, I have to read it. Why should I torture myself? And in this case, the second one, 3872. Here on the ground of delay, you say that the petitioners did not understand the council. As a council, we don't find you very complicated. Your statement will not be understood by your client is not believable. You don't fall into that category of counsel appearing before us whom we can't understand. My esteemed sister also agrees. We don't, both of us don't find you very complicated. Oh, they don't file it. The council will be filing it. I have hardly seen a council petitioner directly filing it. And if they are able to file directly, overriding the council, then they are smart enough. So on the count of delay, we are not satisfied. 2018 challenge has been made in 2025 after 7 years. We have tried, but the explanation we can't accept. And this statement is false. We are more concerned with the false statement. You come to page 36. You're there at page 36. See the first line. Date of printout is 5/3/2019. And come to your statement at paragraph 26. Last two lines. During discussion, the learned counsel pointed out that he is unable to file requisite petition due to non-supply of the requisite land record along with other documents. And Mr. Datta, I have a very bad habit of reading everything. No, I understand, but I have a bad habit of reading everything. We can't permit a false statement in the repetition. We have to dismiss it. No. Who collected it? Petitioner cannot collect because the Jamabandi is with them only. 2019 is the printout. That's why we are showing it to you. But that's not the statement. If they have not given it to the council, it is their difficulty. No case of condoning the delay of latches of 7 years can be made out. No, we are sorry. This can't be accepted. So this, you're not inclined now. We come back to item number 12. Seven 79. And yes, Mr. Payang, here the reference is only against Rahima Begum.
Yes.
It was not against the other person, Samaruddin. Or against Rafiqul Islam. You see this record? Let it- let's see.
And yes,
Authorities find any material against them, they can file a separate reference. Item 11. Heard Mr. U. Dattar and counsel for the petitioner, also heard so for the respondents. Mr. H.K. Hazarika is there for the government. By filing this writ petition under Article 226 of the Constitution of India, comma, the petitioner namely Rahima Khatun alias Rahima Begum, comma, has assailed the impugn opinion dated 16/5/2018, comma, passed by the learned member, comma, Foreigners Tribunal number 1st, comma, Morigaon, in FT within bracket C, that is page 58, comma, thereby declaring her to be a foreigner of post 25/3/1971 stream. Next para. By order dated 14/7/2025, comma, keeping the issue of maintainability open on account of delay and latches, comma, court was inclined to issue notice returnable on 18/8/2025. So in the meanwhile, the as the records of the tribunal were already called for in connection with WPC 4136 of 2019, comma, fresh requisition for the records was not required to be made. Next para. On the preliminary issue of delay and latches, comma, the learned counsel for the petitioner has referred to the statements made in paragraph 20, TO2, 28 of the writ petition, and it was submitted that the petitioner, comma, in course of her evidence, comma, had exhibited the certified copy of the Jamabandi in respect of land covered by Dag number 242 of Pata number 319 of village number 1, Noramari, Naramari, comma, wherein the name of Ajmat Ali, AMJAT Ali, comma, projected to be the great grandfather of the petitioner, was recorded. So it is submitted that after his expiry, comma, the name of Abdul Jalil, ABDUL, JLIL, comma, the name of the comma, the projected grandfather of the petitioner, along with the name of his siblings, were recorded. So the said document was exhibited as Exhibit 6. First of however, comma, the said evidence was rejected by the learned tribunal first off. Accordingly, it is submitted that the Javamadi within bracket Exhibit 6 and the Javamadi, where the name of the petitioner along with her siblings and her mother were mutated, comma, which are annexed to this repetition is annexure L. Would establish the link of the petitioner with her projected father, comma, projected grandfather and projected great grandfather. Stop. In this regard, comma, the learned counsel for the petitioner has referred to the statements made in paragraph 24 of the writ petition to project that the said land record is a vital piece of document which would show that the petitioner has been able to discharge his burden under Section 9 of the Foreigners Act. Stop. Referring to the statements made in paragraph 26 of the writ petition, it was submitted that while preparing, make this next paragraph. While preparing for the preparing for drafting this writ petition, the learned counsel for the petitioner had noticed that the petitioner had not supplied the required copies of land records and other relevant documents However, the learned counsel could not communicate with the petitioner as he could not trace out any contact number. So accordingly, after contacting the counsel who was learned counsel who was engaged, learned counsel from Oregon who was engaged for the trial of the reference case, was contacted, who informed the petitioner, and thereafter the copies of Jamabandi and other documents were supplied to the petition to the learned counsel for the petitioner. So, however, there was again some delay on part of the petitioner to provide the documents, and only in the last week of April 2025, when the state government started the drive to send back the foreign nationals, the husband of the petitioner called the learned engaged counsel to know about the status of WPC 3560 of 2019, filed by the husband of the petitioner number 1, and only then the lack of documents were pointed out, and those were furnished to the learned counsel for the petitioner, and accordingly this writ petition was drafted and filed. Next paragraph. The ground for delay, as projected in this writ petition, is opposed by the learned standing counsel for the empty matters. Next paragraph. On a perusal of the documents appended to the writ petition, it is noted that while the corrected copy of the Jamabandi was applied on 17/6/2025, but Which page was that? But the copy of the Javamadi showing the name of the projected father and grandfather of the petitioner, which is available at page 36 of the writ petition, the printout of the said Javamadi was made on 5/3/2019. In this Javamadi at page 49B, which is the entry you are relying on? Page 49B, capital B, which is the entry you are relying on? Page page 50. MR 2018-19. But the name of this Rahima Khatun is not there. And 50, the name of the petitioner is Rahima Khatun.
So 51 top.
51. However, on a perusal of the relevant entry, which was passed on the strength of order dated 16/5/2019, passed by the circle officer in mutation case number capital MOR oblique MOR oblique 2018-19 oblique 1296 oblique FMUT, page 50 है. About the name of Jainuddin. Now, in place of name of Jainuddin, late, no, not late. It was substitution of. Substitution of the name of Jainuddin, the name of Musammat Rohima Khatun, within bracket, daughter of late Jainuddin, bracket closed, Musammat Abida Khatun, within bracket, father late Jainuddin, bracket closed, and name of Muhammad Amir Hussain, within bracket, father late Jainuddin, bracket closed, and Muhammad Saddam Hussain, within bracket, late father late Jainuddin, and Miss Musammat and Musammat Khudeja Begum, within bracket, husband late Jainuddin, were mutated. Full stop. This is not an exhibited document. Full stop. The said document does not appear to be an exhibited document. Though the order of mutation was passed in the year 2018-19, you don't have the date of the order. Hmm? Where do you get it? Page 51. Oh,
Before the second noting, my lord.
yes. It's not an exhibited document. First of however, the said mutation order was passed pursuant to order dated 29/3/2022, passed by the circle officer Usra. Therefore, the said document is a post opinion document. Full stop. Next one. Therefore, if the petitioner could pursue the proceedings for mutation of the land in her name, there was no impediment for the petitioner to pursue remedies available against the impugned opinion dated 16/5/2018. Therefore, having obtained mutation of the land by order dated 29/3/2022, it is not believable that the petitioner did not have the relevant land records after the mutation was allowed by order dated 29/3/2022. Stop. Therefore, the obtaining of subsequent Jamabandi on 17/6/2025, only appears to be an afterthought and to cover up for the period of limitation. May cover up for the delay and latches in filing the writ petition. Next, but accordingly, the explanation tendered by the petitioner for delay in approaching this court for asserting the opinion dated 16/5/2018 is not found convincing or acceptable. So therefore, on the ground of delay and latches alone, in asserting the impugned opinion dated 16/5/2018, this writ petition fails and the same is dismissed. Next, under the circumstances, there shall be no addressed cost. Next will be the registry shall send back the records, requisition from the learned tribunal, along with the downloaded copy, along with a copy of the order for the record.
মিলা নাই কিন্তু সমাউদ্দিন নেকি ডেটা গানো ইয়াতে জয়নুদ্দিন আছে is 50.
Just a moment. In this writ petition, in the text of the writ petition from paragraph 1 to last paragraph, What is the name of your father? Where have you made statement regarding the name of your father? No, in this, same item, item number 11.
You can pick up the names of Jainuddin. The argument of some of them, yes, sir.
Mr. Yudatar and counsel for the petitioner also heard. So this is for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioners, namely, Samaruddin and Rafiqul Islam have assailed the opinion dated 16/5/2018, passed by so-and-so, page 41. Insofar as it relates to declaring the said two petitioners as foreigners of post 25/3/1971 stream. Next para. The sole ground on which this opinion has been assailed by 2 out of 3 petitioners is that the inquiry as regards the citizenship of the petitioners was never made, and that the Superintendent of Police within bracket border, bracket was Morigaon, had directed an inquiry to be made with regard to the nationality of Rahima Khatun, Rahima Begum, suspecting her to be illegal migrant from the specified territory of Bangladesh, was entered into India on or after 25/3/1971. Full stop. However, no inquiry was conducted in respect of the petitioners herein, and that no reference was forwarded to the erstwhile illegal migrants within bracket determination bracket close by the tribunal determination, bracket close, tribunal under the erstwhile illegal migrants within bracket determination by tribunals, bracket close, Act, 1983. However, despite the reference being made only against Rahima Khatun, KH Rahima Khatun alias Rahima Begum, the learned member, Foreigners Tribunal number 1st, Morigaon, registered the proceedings of case number FT within bracket C 779/2010 in the names of Musammat Rahima Begum alias Khatun, Muhammad Samaruddin SAMARUDDIN, and number 3 Rofiqul Islam ROFIQUL, Rofiqul Islam. Next para. The learned standing counsel for the FT matters has opposed the challenge made in this petition. Next para. It is the records received for the travel is produced. It is observed that the inquiry was directed to be made only against Rahima Begum and the investigating and the inquiry officer had made inquiry only against Rahima Begum, and accordingly the reference by the Superintendent of Police within bracket border, bracket close Morigaon, was only made against the said Rahima Khatun, wife of Samaruddin, within bracket petition number 1. Next paragraph. It is too well settled that the Foreigners Tribunal, in session SEISIN, in session of the determination of whether the person against whom reference is made is a foreigner or not, derives jurisdiction only on a specific reference being made. Next para. In this case, no reference was made by the competent authority, i.e. Superintendent of Police within bracket border, bracket close Morigaon, against the two petitioners herein. Next para. Therefore, the proceedings of case number FT within bracket C 779/2010, which had proceeded, amongst others, against the petitioners, was wholly without jurisdiction. Next para. Resultantly, the opinion, impugn opinion dated so and so, page 41, is not sustainable. Is not sustainable in respect of the two petitioners hearing, namely, Samaruddin and Rafiqul Islam, Stop. Next, for the resultant, comma, the said opinion is hereby set aside insofar as the two petitioners, namely so and so, are concerned, comma, without any interference with the said opinion in respect of the first proceedee, comma, namely, comma, Rahima Begum, alias Khatun, KHATOON. Next para, in respect of the said proposition. No, especially before this earlier paragraph. In respect of the said legal proposition, comma, if one requires any authority on the point, comma, the case of so and so, that I'll give you later. So and so may be referred to. The records of the tribunal, which is tagged with this writ petition, is may be returned forthwith, along with a copy of the order to be made a part of record. Next para, the petitioners shall produce a certified copy of the order before the Superintendent of Police, Border, Murigaon, to bring the order to the notice of the said authority. Just a moment.
Microphone.
This order shall not preclude the competent authority to make an independent inquiry against the petitioners, comma, if so advised, and to take an appropriate action, and to take appropriate steps. Only that much.
Upgraded item 44 for orders.
What is the explanation for the delay in filing the writ petition to challenge the opinion of 2019? that is very vague.
My lord. Moreover, my lord, actually they are poor, my lord. But they had challenged, my lord, after being detained, my lord. They have approached this court, my lord. It is admitted fact, my lord. Here, my lord, the petitioner was detained on 17/5/25, my lord. Basically, my lord, at the this central.
Because if there is no explanation for delay, we are not entertaining.
Then, my lord, I will be allowed to file additional petition, my lord.
Do it because we are
Yes, ma'am.
really not satisfied.
Yes, yes.
Oh. The prayer made by Mr. S. Hopla, counsel for the petitioner. You said both sides are represented. Matters was adjourned today. List after,
Next week, my lord.
list after week.
My lord. Obliged, my lord.
It will be the writ petition. And here you say in view of adjournment in the writ petition, this matters is deferred, list after week.
My lord.
I,
Obliged, my lord.
Upgraded item 40.
Can it be after some time, Doctor? Can it be after some time? There will appear, he is on
hearing
leg.
person.
Mr. Air, where will appear, he is on legs, Doctor, in court number 1. Mr. Air, where will appear in this case, he is in legs, court number 1. Much.
Upgraded item 27 for admission.
May please, sir. Page 14 is the impugn opinion.
I received the instruction, Doctor. I received the instruction. And not to differently taken and father of the procedural highly critical. And earlier, taken appointed out and in this case, a and I have to follow them up. Earlier, by engaging they have applied for certificate to fill 3 years for the system.
Just send the records for a moment. Where is the petitioner? Not here. Then we permit you to meet and get the wakalatama.
My lord, at the time of filing of the petition, my lord, we have stated in our petition, my lord, that when the cause of action arose in 25th May, my lord, she was picked up, and therefore, my lord, we were faced with this dilemma that could we have pleaded on behalf of someone we never communicated, my lord, because she was just picked up and we had no instruction where she was, and nobody in the family could also tell us what her instruction was, my lord. That is why we thought that we should file it in her father's behalf, because that's
It's okay. We permit you to meet. You don't want to meet her?
Yes, at this stage, my lord, I'm praying for bail, my lord, because if
Oh no, there is the difficulty. Because that you can do only when you challenge it. But this is now a habeas corpus petition. No, for it's not a habeas corpus petition.
Petition challenge process.
This perhaps would not be maintainable. Because the third party cannot challenge the opinion. You know why? We are sending you this record. Page 23 of the TCR. You see, this is an application for certified copy applied by Naushad Ali. He is your husband. This certified copy of the entire set of documents are obtained in 2018. The opinion is of 2017. So 18, your husband collects it and does not take any steps.
yes, but this situation is
No, we don't know, because you see, it's a strange world. Many people may like you to be inside. Some people may want you to be outside, we don't know. But we are showing you a document where the certificate copies were applied for. And it's quite possible that the petitioner may not want to reside here.
This document, my lord, it was brought on notice last occasion also, my lord. But our client, the petitioner and her and his daughter, they are, my lord, denying such an application. My lord. They're disputing this.
But Naushad Ali is your husband.
Yes, my lord. But they have never received any information about this, my lord.
No, we don't know. That's why you see, we told you, this is a strange world.
And in our pleadings also, my lord, we had given that the whereabouts are not known, my lord. That is
That
why-
we are getting it to you. You take the. That is subsequently.
subsequent.
That is subsequently. So we don't know. Challenge must be made by the petitioner with her own knowledge. Notwithstanding this, we permit you to go there and meet her, take the wakalatama and then sign it.
My lord, then we will do that.
Heard. Mr. I. Bhattacharya, learned counsel for the petitioner. Also heard Swenson for the respondents. Next para. Pursuant to order dated 6/8/2025, comma, Mr. G. Sharma, the standing counsel for the FT and border matters, has obtained information from the concerned officials of the Home and Political within bracket B, bracket close department, that Musammat, MUSSTT, Musammat, Elijah, ELIJA, Begum, comma, who is the daughter of the petitioner, comma, namely, comma, Muklesh, MUKLESH, Muklesh Uddin, UDDIN, So this will be information from the Senior Superintendent of Police Border, not Home Department. Information from Senior Superintendent of Police Border, Assam. So is comma against whom an ex parte opinion dated 21/11/2017 was passed by the learned member, comma Foreigners Tribunal number 3rd, comma Morigaon, in case number that is at page 14. Case number so and so, reference case number so and so, comma declaring her to be a foreigner post 25/3/1971 stream, comma was apprehended on 20 was apprehended and thereafter forwarded to the holding center, comma Matia, comma Gwalpara on 27/5/2025. Next para. Accordingly, comma the on such disclosure being made, comma but the court is inclined to grant the petitioner, namely so and so, and one family member to visit and meet the detained foreign national, namely so and so. Next para accordingly, comma it is provided that the in charge of the holding center at Matia Gwalpara or at Matia or Gwalpara shall come out having custody of the detained foreign national, namely Elijah Begum, comma shall, comma on production of a certified copy of the order, comma permit the petitioner and one family member to meet the said declared foreign national and to take her signature in the Wakalatama, comma to be authenticated by the state authority. Next para. List the matter on. Give a date after a week. List on so and so.
27th of August.
27th. Okay, 27th of August. The next part, the instructions produced by the learned standing counsel of the matters is retained on record. List on so and so. List on so and so will be last. Okay.
Okay.
Part third item 45.
May please, your lordship.
45. This is parted.
Lordship, my senior is on leg in another court, lordship. I request your lordship to kindly fix the matter on Thursday.
Not next Tuesday.
Thursday.
Okay. He's wanting next Tuesday then. Okay. Next on the joint period of the Land Council for the petitioner and the Standing Council for the FT, and Mr. G. Sharma and the Standing Council for the FT matters. The matter stands adjourned today. List on 26/8/2025. Okay.
Item 23 for admission.
Yes.
The document that they have furnished, allow me to add evidence. These are certified copy of the electoral law of 1971 and electoral law of 1993. Okay, the document that are issued by the NRC authority. So election commission can declare only because the certified copy that is issued by the department. Yes, those two for document they also this is certified copy of 1971. Each of the copies was prices for officer. Digital certified copies are nowadays issued in PDF form, and they are getting provided a PDF, and they can take out and print out. So these are the copies that were provided in the. In this, the first one 1971, the serial number is matching, but the petitioner has taken the printout that they have submitted in a document with the folio alert. There is a folio and also revenue stamp also. But election commission has provided them the copy in this manner. So they could have very well submitted this document because this is certified copy along with the barcode and everything. Okay. But the folio, they have submitted a copy with the folio, and I have seen the record. The copy they have submitted, the true copy with the folio, original folio is not on record. So it clearly seems that this is a photocopy of the document that they have either they xerox from this document rather than submitting the PDF that was submitted provided by the department. And along with the 1971 and 1998, I also enlarged the relevant page of the photo list. The name clearly reflects in the photo list also.
এটা জেনুইন এখানে চেক করতে পারি এটা পরিবেশ করতে পারি
তার আবার পিন করে দিছে এটা সহিটা আছে না ডিজিটাল সিগনেচার
নাই না তার মানে
yes my definition is corrected.
but then where is the original one?
Original only here said it is not submitted. I have collected from my client. See, this I have collected, but it was handed over to the key. I have instructed. But it was handed over to advocate. It is not there.
First one. Show it to Mr. Ali first.
Clearly, they are the request and because they have not even while filing the exhibit, there is no compared, the serial is also not there.
That's the difficulty. Right. আচ্ছা,
কম্পেয়ার ভিডিও
দেখুন অরিজিনাল আছে এটা।
তার মতো না তাতে করবেন কি তাতে করবেন
Sharma, in this case, whether your the submissions made in other cases would apply? You're taking adjournments in other matters, few other matters of this sort. Will this be covered?
No, Lord, he is not claiming citizenship under the law. He is not claiming citizenship under the lordship here. So
You can speak to Mr. Islam.
Let it come up, let it come up.
You speak to him first. If he's not interested, then we will go here on merit.
Yes. Yes. There is no clear instruction as a normal, so.
So you may speak to Mr. Islam.
Yes,
If he's ready, then we adjourn it. Otherwise, we take it up for hearing.
Takes another day.
Okay. Sarika, I think you'll have to take up this issue. Because this concerns the office of the Deputy Commissioner. Just Dadaji. Your time. Because Mr. Araika, these issues must be taken up with the authorities, that is issuance of certified copy by Office of the Deputy Commissioner is something which is under the General Administration Department. Although this is a copy of the election, now who will be the election officer, or it will be the General Administration Department? regulating the issue of certified copy. Because in deputy commissioner's office, he will have to make an application before the election branch. Election branch issuance of certified copies under whom?
Election officer of the deputy commissioner office, he issues the certified copy. But
Or it will be the election branch. No. The state election, there is a state election officer. This functions under the state election officer? No.
CEO, as the CEO of Election Commission of India, they regularly put the data, original data of Election Commission of India, that is not being shared. It is the election branch who has the data that has been shared to the.
Okay. Because you see, there are 2 or 3 things come out. Number one, there must be uniformity in issuance of certified copy. All throughout the state, every district must have the same uniform system of giving the certified copies. That's number one. Number two, in this case, they have given a printout in the in this folio. Now, what happens is that unless this folio and this court fee stamps are cancelled, the state does not get revenue.
Folio provides for
They have taken the folio, because the petitioner themselves, the department has not provided the folio.
Yeah.
So after getting the PDF, they used to purchase this folio along with this revenue ticket. That is why this revenue ticket has not been strike off alert. Otherwise, had the department had issued it, it is a red ink. They have
So they have not cancelled it. It's called cancelled.
So they are not.
Just provide a petitioner.
To get more probative value while finding evidence, they used to get it printed. It is because of that. This in fact the printout has come up in the folio alert.
If they provide.
Okay, so this is an error on part of the petitioner.
Part of the petitioner.
Okay.
If the applicant provide folio, then they print out the folio. Otherwise, they.
And you create a problem. And in the process, you create a problem for yourself.
I was just told while taking the instruction that this is the when I told you issued the folio, but you have not strike. They said this folio is not issued by us. Until we provide only the PDF.
It's okay. We have also learned something in the process. Because we were not aware of it. Okay, in this item you say. Mr. You see, all sides are represented. Next para, pursuant to order dated 28/7/2025, Mr. A.I. Ali, learned standing counsel for the Election Commission of India, has produced the photocopy of various of certified copies of various electoral rolls. Which were provided to him pursuant to order dated 28/7/2025. And he has also produced a copy of printout of the electoral rolls, and it is submitted that the data of the electoral roll is maintained by the Election Commission of India, which can be accessed to the respective election branch of the office of the Deputy Commissioner concerned.
Electoral roll, that is one electoral roll copy is already provided to respect to every constituency. From the electoral roll, by after comparing that, they provide the certificate.
Okay, data is available, we said, no electoral roll is provided. So copy of the electoral roll is provided to the office of the deputy commissioner. And and the election branch of the office of the concerned deputy commissioner issues the certified copy of the electoral roll, which is digitally printed and electronically signed by the concerned authority. Full stop. It is submitted that in this writ petition, comma, photocopy of the certified copy of electoral roll, comma, printout of which is made on a stamp folio paper, comma, is not the mode in which the office of the deputy commissioner would issue a certified copy. Full stop. Accordingly, it is submitted that as per instructions received by him, comma, the petitioner, while downloading the copy of electoral roll, has made a printout in a stamp folio paper Next panel. The learned counsel for the petitioner has produced the original folio paper containing the printout of the electoral roll of the year 1993. And he admits that this is how the and it submits that the petitioner has obtained the printout of the certified copy of electoral roll in the stamp folio paper. Next para, be that as it may, comma, the authenticity of the document which is annexed, which is exhibited by the petitioner is not disputed by the learned standing counsel for the FT matter of the Election Commission of India. Next para. The photocopy of the electoral rolls, comma, is provided to the learned standing counsel for the Election Commission of India, and the printout as produced by him are retained on record. We'll give it back to him. So the next para, the copy of electoral roll, which is copy of electoral roll, comma, a printout of which was obtained by the petitioner in the stamp folio paper, is perused and returned to the learned counsel for the petitioner. Next para. Upon prayer for adjournment made by the learned counsel for the petitioner, the matter stands adjourned today. List after
1 month.
list. List on days. List on 19/9/2025. We hardly have any time to take up any other matters. Any matter which there is some urgency?
Item number 25, Lordship. Kindly peruse the last order. As last order is reflected as the petitioner is not in bail, so matter is utmost urgent.
25.
25, Lordship. Order
Okay,
dated
he is not
11
on bail.
Lordship, 11/6 2025. And 22/11, 2020.
You have received the 2021 opinion now. What is the explanation for delay?
Lordship, I have explained at page number 22, Lordship. The lady is working at Delhi at brick industry, Lordship.
Page 22.
Lordship. Well, page
There is
25, paragraph 22,
25, para 22, okay.
Lordship.
Page 25. These are too vague.
Lordship, the matter was after the interim order, Lordship, COVID-19 was there, Lordship. Lordship, 52 years already, Lordship. So
No, but this is too vague. You've given no details. 21 to 25 is 4 years.
4 years.
And you see, I have a bad habit of talking to people. Have you ever traveled in sectors of Guwahati, Chennai, Guwahati, Bangalore, Guwahati, Hyderabad? Have you traveled
Up to Delhi.
by flight?
Delhi.
You have traveled. Have you seen labor class what you call citizens also travel by that in those sectors? You have seen them. I have spoken to them. Many people have seen them, but I have spoken to many of them. When you travel, when you see a particular class of people traveling in the flight, I had a tendency to ask them. And you know what I am told? At least 3 or 4 occasions, I won't remember how many, but 3 or 4 occasions I have spoken to these people. They say that their contract of employment covers 2 travels to their hometown by flight.
Lordship, I have 2 friends who work at
Then you can ask them.
Lordship.
There are hundreds of people from Assam who are working outside. And I have a tendency, I'm little talkative. I engage in conversation with people with whom I have no business otherwise. I just speak to them. So saying poor would not help you unless you give a complete picture.
Lordship.
4 days back, you read the Times of India, a beggar in front of a particular temple has donated 1.8 lakh for renovation of that temple. 4 days back, Times of India. You just check out in your mobile, you'll get it. News. Beggar donating 1.8 lakh for renovation of temple. And you know the net worth of richest beggar in India? You're not aware. Just check up. Richest beggar in India. He has assets worth 50 crores. You got it? Lady beggar?
Bijangera village,
Huh,
Anjaya Swami temple,
Ah.
1.85.
yes.
Old. 60 years old beggar.
Huh?
60 years old beggar.
60 years, yes, yes, you're right. This is the one. The stories of beggars are many. You'll find in Dubai, check about beggar in Dubai. You'll find a multimillionaire beggar, and incidentally in Indian or Pakistani, I forgot, engages hundreds of other beggars and during this Hajj time, Saudi Arabia. You have got it?
Foreign remittance leakage.
Huh?
I think my idea is it is of Indian origin and foreign remittance leakage.
So when I am not reading law books, I read those. You better make out a good story. This is too vague. We are not inclined, would be dismissing it.
Date may be fixed, but
Oh,
then date may be fixed. Mr. Chairperson will approve the matter.
okay.
Today went to airport for the.
Pardon me?
Lordship, Mr. Chairperson will approve the matter. Lordship, date may be.
No, it would not matter. Today or tomorrow, it doesn't matter.
Okay.
I take the same view. You want an adjournment?
No, Lordship. Lordship, time is not permitting, Lordship, so matter may
No,
be.
time is permitting. 1 or 2 minutes we can spend.
No, Lordship. Then date will
Don't
be
worry.
date may be fixed, Lordship, as per convenience of this court.
Okay. Then Wednesday. Yes, the positive time matter could not be taken up to the list on 20/8/2025. And also read about the richest beggar. He-
Item 1 for delivery of orders.
Good afternoon, brother.
Good afternoon, sir.
In view of the discussions above, the court is constrained to hold that the delay and latches on part of the petitioner in approaching the court to assail the impugn opinion dated 17/9/2019 disentitles the petitioner to any relief in exercise of the statutory jurisdiction under Article 226 of the Constitution of India. So accordingly, this petition stands dismissed. Interim order passed earlier stands vacated. Some corrections, you will get it tomorrow morning. There's something which I would like to point out to you. Yes. You may not have noticed it. Please come to page, you have the brief, page 28.
Yes, Miller.
This is a certified copy,
It's a
photocopy of certified copy.
certificate.
In the right side, you will find a date, application number 1518. Right side,
The date is there,
oh, sorry, left side, huh?
the
Ah.
left side.
1518 is the petition number,
Yes,
correct?
yes, Miller.
And after that, the date is 10/11/2016.
16 years.
That means the certified copy was available with them.
Yes, my lord, this is a normal phenomenon. We see that, my lord. These are very weak, my lord, and very poor. They prefer, even though they get the, my lord, certified copies, and after several, my lord, 1 or 2 years, they prefer the petition, my lord. This is a common.
That's okay, but this too long.
Lordship, on the basis of, my lord, the judgments that I have produced, my lord, the recent orders passed by your lordship, my lord. I was.
We
watching
have
that-
considered all these three judgments you have given.
Yes, my lord.
All the three judgments we have referred to in the order. One is Akash Ali,
Yes.
one is Amran Hussain,
Another is Fakruddin.
and
Another is Fakruddin. It is a recent.
these were two only.
No, my lord, I submitted 3, my lord. The recent one is, my lord, passed by your lordship, my lord. That the delay was also, my lord, for
What
5
is the
years.
name of that?
Fakruddin, WBC 3070, stroke 2025.
Just one moment.
It's a recent order. It was passed on 9th of June 2025, my lord. And
One
there
is
was
Fakruddin,
Fakruddin.
one is Amran Hussain, third is Akash Ali.
Yes.
Okay, Fakruddin also we have dealt with.
Yes.
Here, since we found that it was not in accordance with paragraph 25F,
Yes.
that is the ground, and Amran Hussain we have dealt with, and also Akash Ali, all three have been dealt with.
My lord.
Brother, will rise.